Hello everyone, welcome back. In this video, I'm going to talk to you about the Baker Act and how long you can actually be held. So in order to understand that, you need to understand that there are actually two types of Baker Act here in Florida, voluntary and involuntary. So for purposes of this video, let's talk about the involuntary Baker Act, which can be initiated one of three ways. Either law enforcement, the police take you, a judge signs an order, or the issuance of what's known as a professional's certificate issued by a qualified professional under the Baker Act statute, such as a licensed clinical social worker, an emergency room doctor, a psychologist, psychiatrist, somebody like that who initiates the Baker Act. Those are all forms of involuntary Baker Act, and they typically are associated with the 72-hour hold that you've probably read about online. Now, let me preface that by saying if you were taken to a hospital first for some type of medical attention until you are actually in either the receiving facility or a behavioral health unit, if the hospital has one, the 72-hour clock doesn't begin to tick. It's tolled, meaning it's basically stopped in its tracks. So if you went to the hospital for medical attention and for whatever reason, say the ER doctor decided to Baker Act you, the clock is not running. It's not running at all. And I've seen people, be held at a hospital for, a day, 2 days, 3 days, 4 days, 5 days, and then they get medically cleared, and then they get transferred, and then the clock starts to tick. And so what tends to happen is people will call and say, well, he's been there 5 days, or she's been there 5 days, and now they just moved him or her to the Baker Act facility. Do those 5 days count? And the answer is probably not. They don't count. The statute's pretty clear. They just made a change to it actually for this year. It was made last year, the change, and basically said the clock doesn't start to tick until you are into that Baker Act facility. So the typical detention is up to 72 hours, but it can go way beyond that. In fact, the maximum under the Baker Act statute is actually 6 months at any one time in a state hospital, which is why I always tell families, don't wait. Once you get Baker Acted, if your loved one is being held, the time to fight to get them out is right now. Don't wait and see what happens, because you run a very serious risk that they won't get out. And in fact, not only will they not get out, that the state, and remember, this is a state statute. This is a statute that allows the state to take custody of your loved one. That's who's really detaining them. Even if they are at a private hospital or private facility, it's the state that has taken temporary custody of them. The state can go get that court order and keep them for a lot longer. So you want to fight, start fighting straight away. So that is the involuntary detention under the Baker Act. If they are voluntary, and I'll talk about how that might happen, the hold is potentially indefinite without a court order, and you can be stuck there for a lot longer than the 72 hours. And I've seen it happen, which is why if you've been Baker Acted, or you have a loved one who's been Baker Acted, you got to fight to get them out. And you need to start thinking about making that fight happen right now. So with that said, if you like this video, please give me a thumbs up and please subscribe to the channel. See you in the next video. Bye-bye.